panel discussion. We're very privileged this afternoon to have distinguished panelists, each an expert in many aspects of EB5, including, but of course not limited to our topic of interest retrogression and redeployment. This morning we will study the topics of retrogression and redeployment that we believe is in the minds of everyone who's involved in EB5 as a stakeholder. We will analyze the relationship between the two. How does one give rise to the other? We will offer some solutions to deal with this reality. In some cases, our suggestions will mitigate the risk, and in some cases, we hope will eliminate it. Finally, we will wrap up our discussion speaking about industry trends, pending reforms through rules, regulations, and legislation. And without further ado, I'd like to introduce the speakers. Myself, Marco Isiber, I'm the founder and CEO of America EB5 Visa. Our firm's mission is to connect international investors aiming to immigrate to the US with EB5 issuers, typically real estate developers who use EB5 as an alternate source of funding. I'm also the managing director of Riverside Management Group, where I'm responsible for the firm's EB5 activities. Previously, I was managing director at BNY Mellon, leading the firm's financial institutions derivative sales business globally. I'm a graduate from Wharton at Penn, as well as Boğaziçi and Robert College in Turkey. To my left, Phil Cohen is Vice President of Altitude Advisors and is an investment advisor representative. He has been involved with EB5 since 2010, initially as the founder of Service Provider Strategic Element, which participated in project teams raising over $3 billion in EB5 capital. He is the lead author of the EB5 Definitive Guide and a regular participant as a conference panelist and writer of articles in various industry publications. In 2017, he joined Glide Capital, a registered investment advisor, with $350 million under management to form their Altitude Advisors division, which focuses on presenting Glide's unique platform as a way to address redeployment to the benefit of all stakeholders. Brad Stedman is president and partner of Capital United LLC, a registered investment advisor with the SEC, where he advises clients on appropriate investment strategies, then analyzes and oversees all investments throughout their life cycle. He has extensive experience in every aspect of real estate development and finance. Mr. Stedham is also president of an affiliate company of Capital United, EB5 United LLC, which has raised over $440 million throughout the EB5 program. Prior to Capital United, Mr. Stedham was a trusted consultant for BlackRock, the largest investment manager in the world. Previously, he was on the executive team of Poly Group, a prolific Santa Monica-based real estate development firm concentrating on residential, mixed-use, and hospitality projects. Mr. Stedham received his BA from Boston College and his MBA from the Anderson School at UCLA. And finally, Akim Vaziri is the managing director with Verve, where Mr. Vaziri helps underwrite real estate hotel and multifamily projects and provides with the EB5 financing of those projects. He has worked in all aspects of evaluating hotel assets, from evaluating investments in the hospitality, gaming, and lodging industries at two long-short equity hedge funds to analyzing the development of hotels and executing traditional and EB5 hotel financing. Prior to Verve, Mr. Vaziri was the director of Greystone EB5 practice, and he was responsible for over $44 million of EB5 funds raised. He earned a Bachelor of Science in Computer Science at the University of Texas at Dallas, and MBA in Finance from the Cox School of Business at Southern Methodist University. Mr. Vaziri also obtained a JD degree from Fordham University School of Law with a concentration in Finance and Business Law. All right, without further ado, I would like to start our discussion. Would like to ask my first question to Phil. The way we're going to do it is we're going to go around asking the questions, and one person will answer and the others will comment. Phil, can you offer any new insights on interpretations of the policy on redeployment as it stands. It used to be that once the funds were used and the project was built, after a refinance or sale of the project, the funds were able to go back to the escrow, awaiting repayment back to the investor. Today, USCIS has made it very clear that the funds have to be at risk until at least the completion of the sustainment period, which is the fulfillment of the 2-year conditional green card permanent residency period. Since I-526 approvals are taking longer than ever, even without any retrogression considerations, investors being left with the risk of redeployment. Without any further ado, go ahead, please. And after Phil, as I said, Abdi and Brett, please.
Thank you, Marco. There is one thing that I would like to point out, which will set the stage for some of the other things we'll be talking about on our panel today. And we'll also be circling back for some other insights. First, to quickly recap the rule, as you pointed out, if the job-creating enterprise pays back the new commercial enterprise before the end of the investor sustainment period, capital needs to be redeployed to an at-risk investment that is consistent with the scope of the new commercial enterprise. In particular, I'd like to bring attention to the statement that says that the new commercial enterprise may redeploy capital to one or more similar loans as the original EB5 loan from the NCE to the job-creating enterprise. So by indicating one or more similar loans, USCIS is effectively opening the door to diversification and redeployment. And I think that's an important point as stakeholders in the EB5 consider their redeployment strategy. Given that capital preservation is a key concern among investors, and also that traditional investment advice suggests that investment risk can be mitigated with diversification, I believe that we can expect the standard for redeployment to evolve to favor diversified strategies. Bear in mind, the investor community has changed considerably over the last 5 to 7 years and are more connected to each other and more inclined to stand up for themselves, as we've witnessed with some recent lawsuits. Ultimately, I believe that those regional centers that prioritize investor safety and still deliver reasonable returns relative to the risk will best serve their investors, and in so doing will go a long way to developing and maintaining strong reputations.
Yeah, I don't know. I'd add a couple of things, I guess, Phil. I think that's a great summation. But the guidance has been poor from USCIS. Whether you can specifically do a fund or not, it's a little opaque. Whether a like project has to be, if you did hospitality, does it have to be hospitality? If you did real estate, can it be any real estate? If you did apartment, could you then go to hospitality? Does it need to be a new development deal? No, we don't think so. Does it need to create jobs? No. But we're wading through a morass of questions because the guidance has been poor. We've asked for further guidance from the USCIS. And I think the general industry feeling is if you make best efforts to keep the capital at risk, somewhat within the framework that has been provided by USCIS, which is again large and confusing and opaque, then your investors are going to be fine. I just don't see them denying 829s based on a redeployment decision as long as the capital is at risk, not in marketable securities, which seems to be clearly defined from their last set of guidance. And so we're all just going along doing the best we can, keeping the capital at risk, doing redeployment, trying to be still a fiduciary responsibility to our investors, and go from there until there is further guidance that makes it clearer.
Thank you. So may I turn you now to this view? I know that at Brevet you pioneered the portfolio investment approach. In other words, when investors invest with you, your company, they can diversify their risk across multiple projects that represent your current EB5 portfolio. Regulations are demanding the regional centers to reinvest and deploy the capital into new projects. This activity is designed to reduce regulatory risk. However, while doing that, it leaves the investor in a way powerless. Going into the original EB5 investment, the investor does a ton of due diligence work to make sure that they are investing in a sound project. They check the LTV of the EB5 loan, senior loan, and there's a sound lender. The project is viable and the list goes on. Once the project is completed though and is sold or refinanced, the idle funds cannot be put back into the escrow or returned to the investors who are not ready to take back their capital? What do you do to balance the risk associated with reinvestment due to regulatory requirement and the risk arising due to the capital preservation objective of the investor?
Thank you, Marco. And to Brad's point, I think the USCIS has not given a lot of guidance in terms of what you can do, and keeping the rules of redeployment very, very broad, as historically they have done. But one of the things I feel like they're signaling is basically they're forcing regional centers and EB5 fundraisers essentially to become fund managers. And the reason for that is, as everyone knows, historically EB5 loan terms are always, in traditional loan model was 5 years. And the reason for that was whether you're investing from China or from Taiwan or India or Vietnam, wherever you're investing from, the whole process from start to finish would take 4.5, 5 years. So a developer would refinance a loan, after the 5-year term, and all the investors pretty much have been approved, and they would pay back the investors. And as the timelines got delayed, you see developers were doing the 5+1 loans and the 5+1+1 loans. But now, if you look at it, based on the information that Charlie Oppenheim gave us a few months ago, now you have investors that could take as little as 4.5, 5 years, and then you may have investors that may take 16, 17 years. So as a fund manager or as an EB5 fundraiser, if you're doing a project where the mezzanine portion, the EB5 portion of the loan is $100 million, it's not like you can go and refinance 200 times to pay back all these different investors at different timelines. It's either you have to refinance a few times, or now you have to figure out how to redeploy your Indian investors, how to redeploy your Chinese investors, and you get in this game of trying to manage all these different investors and all these different timelines, and it's a disaster. And the only way really that I feel that you can solve that problem is to have a fund where there's always investors coming in and going out, and there's always projects going in and out, and there's liquidity to be able to pay these investors back at different timelines. I mean, Brad has a great product that addresses that. There's other groups in the industry that have products that address that, but the days of having a traditional loan model that you do a 5-year loan and you expect to figure out how to pay back 200 different investors at different timelines, those days are over. I mean, I just don't think that you could do the traditional loan model. And there are people still doing the traditional loan model, but 7 years, 8 years down the road, are either going to have a bunch of really upset investors that, the earliest ones have to maybe wait 16, 17 years to for the slowest investors to get paid back, or they're going to have to figure out a strategy to refinance 200 times. So our model has kind of addressed that by having a portfolio model that has 5 projects in the portfolio. Every year we're adding 2 projects into the portfolio. Every year there's a couple projects paying back, but the investors are tied to their own fate without regard whether they're from Taiwan or from Hong Kong or from India or from China. And really the only way to solve that problem, I think, is EB5 fundraisers are going to have to become either fund managers, or they have to rely on fund managers like RAD and other products in the market that do exactly that.
Thank you.
Just to add one thing to that, in relation to your specific question, or managing the risks, or balancing the risks between capital preservation and the regulatory requirements. From my perspective, we noticed that the conservative advice from an immigration law perspective is to redeploy to a project that's as similar as the initial project. On the other hand, the conservative advice from an investment perspective is to redeploy to something as low risk as possible or diversified. So what we say is, to Brad's earlier point about the broadness of the rules and being able to interpret them broadly, and not thinking that investors would be denied for a relatively broad interpretation. We encourage NCEs to consider the middle ground, in particular because redeploying to another project in their lineup can possibly be perceived as a huge benefit to the NCE with perhaps not as much benefit to the investors.
Thank you. Okay, I'd like to get back to Brad, if I may. Could you please, Brad, comment on the best practices with EB5 in general and redeployment in particular to avoid litigation and protect the rights of the EB5 investors? For example, why is it beneficial to notify the investors before reinvesting their funds? How could we make them feel empowered and not feel that they are being taken advantage of? Some say that it's hard to stay compliant with the USCIS guidelines that state that the funds must be at risk until I-829 filing or approval. For example, are there benefits for the investors of having EB5 sponsors using third parties to review their proposed redeployment? Last but not least, why should the regional center in charge of the reinvestment be very careful in following the fund's governing documents, such as the private placement memorandum, and etc., or the other documents?
Sure, and I think it's a great question, Marco. What are the best practices for redeployment, and how do you navigate these waters and avoid litigation? We've seen a couple very large EB5 players already have been sued over redeployment when they, even though their documents allowed them to redeploy without investor consent, they got sued and then later had to come back and provide optionality. So it's at the crux of it is that the GP of the NCE is the fiduciary responsible to these investors. Now, a lot of times, now it's different, but a few years ago when these investors made this investment decision, they had no idea that they were going to wait 15 or 20 years and be subject to redeployment. So fundamentally, that is a material change. Now, if you can get a differing opinion from, you talk to 5 securities attorneys, you get 5 opinions, but there's fundamentally that this is a completely new investment than their original investment decision. They signed a subscription agreement and a limited partnership agreement and wire money into an account controlled by to go and invest in. And so, what do you need to do as a GP to protect yourself from being sued? And how do you fulfill your responsibility to these investors? So, one easy way is investor consent. You can provide optionality. You can give them, choices in investments to make. Some might have a higher risk-adjusted return where they actually benefit from it. So we are seeing in the market that instead of keeping this investor at a quarter point or a half a point, when they do make a redeployment, particularly if it's in another development deal, when they don't need to take development risk, these jobs have been created. They don't need to go in and take development risk, but the yield might be higher for the NCE and the GP of the NCE, then they're sharing some of that yield to the investor or giving them a choice in taking a higher yield, riskier, risk-adjusted investment in a development deal, or maybe something cash flowing that's a lower yield and a lower end return to the EB5 investor. The point that Team brought up is a very good one, and Phil mentioned it as well. Diversification. Do you want to do a single asset, or do you want to do a fund? Now, an immigration attorney might tell you that a single asset investment is closest to the original investment, but you need to balance that with the end investment, the overall investment on a risk-adjusted return, what might provide lower risk, potentially lower return as well, but maybe not, and diversification by investing in a fund. And so those are decisions that NCEs need to make on counsel, proper counsel from their securities attorney and their immigration attorney, and taking it all into consideration, what the original asset was, how they try to remain similar to the original asset, and also keep the capital at risk and provide an appropriate risk-adjusted return for both themselves and potentially the network partners and the end investors. So the other key thing that I think insulates NCEs from litigation and liability is to have an independent third party involved in the transaction. So everyone had it's a real estate deal, they had an issuer's exemption, and in order to not be a broker-dealer and take capital and invest into a real estate deal. But when you're providing advice on multiple investments, which you might be doing in redeployment, you're certainly doing 2, because you're taking the original asset and then providing advice in a third or second, then you would want registered investment advisors. Some NCEs are registered investment advisors. Some NCEs will want to hire an independent third-party registered investment advisor in order to help them advise their clients on different investment options that satisfy both the immigration and the securities requirement. So I think all these things come into consideration. It's all about, we've seen it already. Again, very large EB5 sponsors have been sued. You want to avoid that. How do you avoid that? And it's going back to your original role in this as the GP of the NCE, having a fiduciary responsibility to all your investors and providing them alternatives and appropriate risk-adjusted return, working with independent third parties, working with fund administrators to track the funds and really make sure the capital is, we all know about the sordid history of fraud and everything else with EB5. So how do you provide the appearance and really the actuality of being completely forthright and transparent? And that a lot of times comes with independent third-party oversight that you pay for. So the NCE knows this capital is only going, they wired it to the limited partnership or the LLC. That goes to the developer, comes back, goes to a redeployment investment, comes back, and ends up going to the investor when they attain their period of sustainment. Now, liquidity is a main concern as well. Abteam touched on it in talking about a portfolio or a fund model. These guys don't, if you're, they all have different time frames, whether you're retrogressed from India, Vietnam, China, potentially now Brazil coming, and the Vietnamese investor that can get paid back a couple years after the original repayment doesn't want to wait another 10 years if that's where 75% of the investors from China have to go. So can you provide liquidity in your redeployment option? That would be best practices, so you can pay investors back individually. That probably doesn't come, though it might, with a single asset development deal. If you have a structure with a fund structure where capital inflows and coming out, then you can repay your investor in a reasonable amount of time, a quarter or two. So just to highlight a few best practices that we think are around the industry people are adopting and what we're seeing in this ever-evolving market of redeployment.
Thank you very much, Brad. I think we're focusing on here, as we should, return of the investment as opposed to return on the investment. The next question I think I'd like to ask to Phil and start talking about a little bit return on the investment, on the redeployment after the initial period. Bearing in mind that the return of the investment is, of course, our major concern. So, Phil, do you have any comment on the viability of making investments into public market vehicles, for example, secondary market stocks or bonds, as a redeployment strategy? When it comes to redeployment, especially after the funds were initially invested, say 5 years, would you be in favor of sharing the lion's share of the returns with the investor? It's not being done right now. In an 80-20 split or some other mechanism like a hedge fund. There is no requirement in the USCIS guidelines that most, if not all, of the returns on the reinvested funds cannot go to the investor. Perhaps after a certain lockout period, the investors should be able to benefit from the fact that they are keeping their funds at risk. This would satisfy the USCIS guideline, but at the same time would allow investors to be able to get some returns on their monies that are being locked up, for a long, long time. Thank you.
That's regarding your first question on public market vehicles. It's an interesting question because I've spoken to some regional center operators who have said they intend to redeploy to public market vehicles, which is an interesting possible interpretation. Bearing in mind I'm not a lawyer, I'd like to look again very quickly what the policy says. In particular, it says that if an NCE loan funds to a JCE for residential construction, an allowable alternative for redeployment in that scenario would be an investment into new issue municipal bonds. I think in specifying new issue, we see possible clue as to what the intent was here. Why would it matter if it was new issues? Well, one thing that occurs to us at Altitude is that the difference between new issue bonds and secondary market bonds is where the money goes from the investor's pocket. In other words, when a new issue bond is purchased, the funds go directly from the investor to the entity borrowing the funds. By comparison, secondary market bond purchases see funds essentially transferring from one investor to another. So by specifying new issues, it may well be that the intent is to maintain a direct connection between the borrower and the lender when it comes to redeployment. And extending that example a little bit further, where instead of a loan there was an equity deal, it may well be that an acquisition of new issue stocks may be viable, but I would question whether secondary purchase of stocks would be viable. In any case, it's pretty vague in terms of instruction there. Regarding sharing redeployment proceeds with investors, I not only agree, but I personally believe that it's an act of good faith, recognition of the investor's plight, in the sense that they're being unexpectedly forced into continuing their investment and their risk far beyond the original time horizon. So certainly the NCEs, in many cases agents, should be compensated for their efforts in managing and being involved in facilitating the redeployment. So redeployment is a risk and an opportunity that none of the stakeholders have anticipated. As such, I think all parties should get reasonable benefit. As to what proportions, that's a matter for negotiation, I imagine.
Great. Thank you. So, Abdin, at this point, since our panel is retrogression and redeployment, I think it's fair to talk about a little bit about retrogression. So, as we all know, China is leading the pack in retrogression. Some say 17 years, some say 20 years, some say 25 years. Who knows? I don't know what the real number is. Before they can get a conditional green card, let alone their money back. We're all waiting for some kind of reform here that will address the retrogression problem. One of the solutions that's being discussed in the Hill is to totally abandon the per-country quotas, as was discussed in the panel before, that are imposed per year, and go to this fight for first in, first out method. The House, surprisingly, agreed and already voted on a bipartisan basis for this and passed the bill removing the country cap on green cards. This becomes the law. There's no question that it will be beneficial in clearing the Chinese backlog. Perhaps in about 9-10 years, the 50,000 people who are waiting will be processed. Indians will also greatly benefit. However, what will happen to the rest of the world? Chances are applications from the rest of the world will decline substantially. Besides recent applicants born in countries that are processing current right now, who have already filed I-526 petitions. If their petitions are not yet approved, will be put on the back of the line. I do not think any one of us wants to see this eventuality, and frankly, thinks it is fair. But that said, something must be done. Due to the retrogression in Vietnam, we're already seeing the number of applications slowing down. The panic for the India-born applicants has started. There's also the age-out issue. We've already mentioned that people are concerned about the repercussions of retrogression as it relates to redeployment that we have been talking about and the long waits to get their green card. Or just as bad as the age-out issue. It does not seem fair that a family of 5 with kids 18, 16, 13 who apply for the EB5 together, and the eldest or maybe more of the kids age out. The good news is that, as we know, the age of the kids will be frozen at the time of I-526 filing. When the I-526 is approved, though, the ages are unfrozen. If the investor cannot file for adjustment of status within, say, 3 years in our example, the eldest child, who was 18 when his parent filed for the I-526, will age out. While eliminating the per-country per year quota seems unfair for the rest of the world that is processing card now, perhaps Congress should consider eliminating the age-out feature of the EB5 application, or slow down accepting new applications from candidates who were born in countries with severe retrogression.
Yeah, I mean, there's a lot of questions in there. But, just to summarize what Marco alluded to, basically, HR 1044 eliminated the per country cap. The current wait time from China right now being 16, 17 years. Even with eliminating that, the wait times may come down a couple of years, maybe to 14, 15 years, but it's still not enough to do anything to be able to convince Chinese investors to come back to the table and invest in EB5 if their investment today will equal a green card 15 years from now. So that's not it's not really moving the needle much. The same thing with India. The wait time's about 7 years now, but they do away with it, with the per for a country cap for India, Vietnam, maybe that wait time will come down to just, very, very minuscule. It's not going to really move the needle. But the important part of that, that Mark mentioned is basically all of the groups out there going out and trying to develop new markets, whether it's in Southeast Asia, the Middle East, or South America. Those countries that now may take 5 years from start to finish because they don't have retrogression may now look more like 8, 9, 10 years. And not only you have to go try to build a new market. Not every country has the machine or the infrastructure that China has in terms of having people that understand EB5, know EB5, and having the infrastructure in place to raise the funds. These other markets don't have that. And if you were to go now and try to raise investors and tell those investors, oh, not only I'm teaching you about EB5, but also it's going to take you 10 years to get a green card, it's basically going to kill the industry.
It's going to kill the market.
Yeah, and it's death by 1,000 cuts. And as an industry, to be a little critical of our industry, is we've always been playing catch up. And all of these, it's like having a million different holes in the wall, and you're trying to plug them with your fingers. The key issue really here is we need additional visas. And the only way to really fix this retrogression issue is by getting additional visas. Everything else doesn't really matter. And it requires an act of Congress for the Congress to act, literally. So to get Congress to do away with the age-out issue, to get the Congress to act on anything, it's going to be a very difficult task. So the easiest part is just to get comprehensive reform and to get the USCIS or Congress really to act to get away from the 10,000 visas counting against the family numbers, but also maybe a one-time clearing of the backlog and then adding the additional 10,000 visas where they would only count against the investor, not the family. That would fix the problem. All these other things, the 1044 and all these other things that we're talking about is just playing catch up. Every single one of these things with 1044 were to go through, which it looks like it will, it's basically going to kill the industry. And the real long-term solution is additional visas. That's the only thing.
An easy fix would be just to interpret the law that it is applicants and not visas.
Yeah, but
that's in a family of 4. You're talking about going from 2,500 to 10,000.
Yeah, and that's part of the recent draft legislations that have been floating around. That has all every one of those that has been the intention. But I think as an industry, we're sitting here playing catch up and fighting amongst ourselves for this small number of visas that are available. But really, this long-term solution is Congress acting and fixing this. In the totality of visas, EB5 is less than 2% of all the family and employment-based visas, but we get obviously all the bad press out of the other 98%.
Right. I mean, I would say personally, I don't think 1044 is going to pass. I think regulations are dead, and I think legislation is hopefully going to be a rider on the omnibus bill by 9:30, and we'll be punted along with that, and then hopefully we see some change when the federal budget is finally approved with the omnibus sometime this year or beginning of next year. I mean, I think that's what we're all hoping for with the industry. So no one knows. It's a big question mark. It's difficult for all of us to plan our business when there could be a game-changing immigration bill, there could be regulations, there could be legislation, or there could be not. We've been hopeful for this for years, and it just keeps getting punted down the road every time. This year does feel a little bit different. All the constituencies seem to be tied in together on the legislative effort, whether that's IIUSA, the EB5 Investment Coalition, the Rural Council have all penned this recent bill. There seems to be bipartisan support. Fingers crossed. And within that proposed bill, there is derivatives, eliminating derivatives, and visa relief. Whether those stay in the bill by the time it's passed is a coin flip. But I think for all of us to plan our business, we just need something. We need the legislation to pass. I think that's the best alternative, and I think what most of us in the industry are hoping for.
Thank you, Brad. Actually, the next question I was going to ask you, if I may, we're aware that you have a partnership company with 2 other companies offering EB5 deployment program. I'm certainly very curious to know more about it. How does it address the capital preservation objective of the investors while being compliant with the redeployment requirement that we've been talking about? And how does it differ from the other approaches you've seen in the marketplace so far?
Right. Sure. Thanks, Marco. That's a great question. We've known the redeployment issue has been coming, and it's still coming and growing, and only for the billions of dollars. There's more redeployment capital available than EB5 capital on an annual basis now going forwards, and it's only growing. And so what we try to do as we have a hat that we wore as an NCE. We've raised hundreds of millions of dollars as an NCE, understood this issue, and tried to create a solution and best practices that we could offer to all our colleagues, all the other NCEs in the industry, if they need the help in doing the redeployment. So to that end, we had always been a client of NES Financial, the largest EB5 fund administrator in EB5, and who have billions and billions of dollars under management. And we thought that was always best practices, utilizing them to oversee us, making sure our investors felt secure where the capital was going, and tracking the funds and tracking our investors. So we partnered with NES. We also partnered with another NCE, Greystone, very large real estate service firm, top 5 Fannie, top 5 Freddie lender, FHA. There's large 1,000 apartment developer with thousands of apartment units under management, just a very large, diversified real estate company. And their business, and they're a large lender, is number one FHA lender. They underwrite real estate deals. So our idea was to have a platform where people looking for capital can be married up to people that have capital to redeploy, NCEs. So whether that's developers or other NCEs or funds, we provide alternatives that try to meet each NCE's appropriate choice for redeployment, and provide their investors a risk-adjusted return and provide alternatives to people. So our role in this is the RIA, which you need an RIA, a registered investment advisor involved. We're registered with the SEC. And so that's the main goal here, is to try to put people together that need capital and want capital. And when an NCE is redeploying in their own deal, and as when it's a combined JCE and the NCE are affiliate entities, they want to do that. I think that they want to reuse this capital as long as possible. And you can make an argument that they believe, from an immigration standpoint anyway, that that's in the best interest of their investors, because it's the most like deal. If it's a residential developer and they take that capital and they redeploy it into another residential deal that the same developer's doing, even though it takes development risk, that's the most similar and could be construed as, from an immigration standpoint, their best option. And when that is the case, we are involved as the independent third party and provide that development, because you have an inherent conflict of interest. The JCE and the NCE are the same. The NCE is investing their own capital in another of their own deals. It should be underwritten by a third party. The funds should be monitored and reported, and you should have an independent third party registered investment advisor in the mix. So that's basically what we're trying to do, Marco, is offer solutions to people in the market that need to find their own deal if they don't have a deal to redeploy to maintain the at-risk requirement, or B, when it's a NCE reinvesting with an affiliate entity into another job-creating entity or another developer, a development deal, to be the independent intermediary. And I think that investors like that. They want to see some transparency and independent oversight and reporting features. And, again, that's what we believe is best practice for the industry and why we created this platform with NES and Greystone.
Thank you, Brad.
Yeah, and just to add to what Brad said, the most important thing is to have a best practices plan in terms of how to handle redeployment. And best practices is not just not getting sued, but also making sure that you're treating your investors right, making sure you're doing what's right for the investors. And I believe, really the two options to offer investors to make sure that you're doing best practices is either in the beginning have a fund and let them know that this is where we're going to invest your funds and this is the manner we're going to invest your funds, no matter what. or at the end of the initial investment period, give them redeployment options, whether they have an option to find different investment options and they could allocate those separately or allocate 100% into one, but give them optionality. So the fund that we set up, we do the former, which is basically telling investors exactly where we're going to invest in. We actually have one project just paid back, so we have 5 projects, we have 4 projects left in our portfolio. But our model is, we put up the bridge financing before the investors invest in, so every project has the same exact underwriting metrics, where we put up the capital to be in place with EB5 financing later. We're requiring 20% equity, we get completion guarantees, surety bonds to make sure the project gets completed on time and on budget. But every project has the same exact underwriting, and in the PPM, we tell them that right in the beginning. And we have 3 projects that were approved by USCIS, but we had this interesting dilemma. We had a project that was a hotel project in Dallas that paid back, and the dilemma was where we redeploy these investors within our fund. So we have multifamily projects, and we have other hotel projects. Even though the USCIS rule says to invest in a like project, that's again subject to interpretation. So to be on the safe side, we redeployed into another hotel project. The initial project was a hotel project in Dallas with 250 keys. The redeployed project was a Nashville hotel with 250 keys. Just to be on the safe side, we deployed into a multifamily project. But, again, the USCIS is not really providing a lot of guidelines and a lot of guidance in terms of what is another like project or what's a commercially reasonable timeline. I sat there and watched Robert Devine at the USCIS headquarters in New York asking those exact questions, and their answer was always, we can't tell you. You have to apply, and we'll tell you if that works or not. So that's how the reality we have to deal with. But the important part is just have the best practices where the investors either get to see exactly what the underwriting metrics and the redeployment metrics are in the beginning, or they have the option to decide what they would do with their investment after the initial investment period.
So, one of the formidable tasks each one of you deal with is managing timing of investor exits. Investors come into the project at different times. They have different approval periods depending on their source of funds situation, retrogression, individual background checks, and even the style or the mood of the officer reviewing their individual case. Once the funds are invested, unless you have some monies on the side, it's almost impossible to pay investors back as soon as they file their I-829s and are eligible to get back their initial capital. Can you briefly comment on how you perform this task while complying with regulations at-risk requirements on the one hand, and speedily returning capital back to investors on the other hand?
So thank you, Marco. I think I'll just start by stating that in a sense what we do is a combination of what my colleagues on our panel are doing. We have a platform, and the platform consists of multiple funds. So the team behind Altitude was established 4 years ago. It was not established strictly for EB5. And what they did was they developed a platform of funds and fund managers. They reviewed over 400 funds, have selected only 25 funds to be on the platform. And what that does is it creates a benefit with regard to what you're talking about in the sense of timing. By having multiple funds on the platform, some of the funds have a lockup period, some don't. So that opens up the opportunity to create tranches of investors within an NCE group or within a specific project group. And based on the specific investor group's needs, we can facilitate exit timing according to each group's needs. And similarly, because of our relationship with the funds on the platform, there's also the possibility to negotiate for unique circumstances, particularly larger redeployments.
Excellent, thank you. Questions?
Liquidity, that goes back to the best practice. And a development deal isn't liquid. How do you balance, that if you don't provide liquidity that you might be able to do from a fund that has constant cash inflow and outflow? You work on some of the other things that make it more attractive, on a risk-adjusted return to your constituents involved, your end investors. So, right, these things are a balance and a mix, and I think that's part of an NCE's decision on what the best redeployment investment is taking all these things in consideration, and liquidity is a big consideration.
Thank you, Ray. So, I'd like to ask one last question. We are almost out of time. We have a question or two from the audience. NCEs have a very serious task. We've heard so far from all of you the importance of having a redeployment strategy that's compliant, realistic, and provides as much security as possible to EB5 investors within the laws and regulations that govern EB5. So last question is, when is a good time for an NCE to start planning for the redeployment strategy? On the one hand, it cannot be too soon, because by the time the funds will be available, those opportunities will most likely not be around anymore. On the other hand, it cannot be too late, since the moment the funds are available, they need to be reinvested as soon as practically feasible. So there's this balance that they need to make. What's your advice on strategy regarding this matter for the NCEs? Maybe Abdin, you want to start that?
Yeah, I think if you start thinking about redeployment strategy after you've already started your fundraising, I think you're too late. I mean, I'm a little biased, but I think your redeployment strategy should be in your PPM, and I think you should contemplate that before you even start going to fundraising. I was on a panel, and one of the gentlemen that was on the panel with me was a developer, and he made an interesting point. He said, I'm a developer, I signed up for 5 years. Now I'm in this for like 15, 16 years or more. This is not what I signed up for. I'm not a fund manager. This is not what I want to be doing. And I think that's really interesting because, the USCIS is essentially forcing people to become fund managers. So you either have to partner with a fund manager, or you have to decide, I need to have a fund that has, 15, 16-year life, because there's people's lives and there's people's money at stake, and you have to be their fiduciary. You have to make sure that they're taken care of. And right now, that timeline looks like 15, 16 years, maybe longer. So I think the sooner that you start that process, the better. And I think before you do PPM, you have to have that contemplated.
I agree, team, but you also have to consider that deals done 3, 4, 5, 6 years ago, people had no idea,
right.
And so again, for those people when to start planning for redeployment, I mean, you know a window when your developer is going to pay you back, and you should start investigating alternatives who you want to work with and potential options. But Marco, your point's right. If you look too early, it's that whatever you're looking at is not going to be there when your capital comes. So it's reasonable within a few quarters ahead of when you anticipate your capital being repaid. And I think most people know that with their relationships with the JCE, they know when the money's coming back based on the loan term or whatever the other terms are in the loan agreement, the PPM. But right, I mean that's the time within the year of receiving the capital if it's not today. Okay.
Yeah, and just one more point. I think as more redeployment happens and more new products, I guess, enter the market, groups looking at doing new issue bonds, giving investors more options, maybe investing in the REIT share. I think as more and more of those options become available on top of deployment, the deployment funds that already exist, I think that just ends up being better for the investors because they have more optionality as opposed to a new structured project that may be able to put in securities, whether it's new issue bonds or REIT contract or REIT fund.
I agree with what both of you said, and I would just add that I think that in a sense, it's never too early to start strategizing and thinking. Certainly, the investments you look at today may not be available tomorrow, but on the other hand, it's good to look at what's out in the market to get an idea of what you think would suit you as an NCE, what you think would suit your investors. So in that sense, I think for anybody, the time to start planning is now. There's lots to consider. There's investor buy-in, terms and conditions to negotiate, there's due diligence to be done. And the nice thing about looking at funds is if you look at a fund manager or how they approach things, certainly what they've invested in today may not be there in several years' time, but to know which fund you like today can be of great benefit to you down the road so that there's less decision-making involved and you can start cultivating investor buy-in sooner.
We're out of time. We can ask one question maybe. Is there any question from the audience? Yes, there is. Okay, please go ahead.
Speaking of time 2026 approved, or by the time investors start to land in the US? That's one question. Second question is there nexus requirement between the original NCE and the new NCE, or at least the regional center operators kind of related to new NCE where the fund will be redeployed to in terms of management, shareholding of NCE, or what is the nexus requirement, or no such requirement at all?
I think that's a great question. You know, it really depends on the timing of the developer. You know, we have developers that that we finance their real estate projects. You know, they have anywhere from a 3-year loan term to a 5-year loan term typically, and they expect to be able to pay that loan back. You know, a lot of times construction loans are a little bit more expensive than performing loans, and the idea is they want to refinance and get a better long-term financing option. But it really depends on the developer. I mean, as an NCE, your job is to, you have two clients. On one side, you have a developer, you have to make sure that you're doing what's right for them. On the other hand, you have investors, and you want to make sure what's right for them. So your job is, as a referee in the middle, to make sure you're treating them both right. When I was at Greystone, we had a developer who, we had a 5-year loan with 1-year option, and we told him about the redeployment and how, it may be that these investors may take longer, and he said, fine, I'll extend this loan term to as long as I want. I'll just pay those investors back from equity whenever they come due. So let me extend this loan for as long as I can. I'll just pay it back one by one as they come due. So that's an option. But you find a lot of developers that they want to be able to pay back those loans as quick as possible. So as an NCE, your job is to try to redeploy those funds because they have to do what's right for their project.
Right, it doesn't really have much to do with the I-526 approval or not. I mean, I think that was your first question, in the sense that there's always, not always, but most of the time, there is the NC making a loan to the JC. So when that term is done, let's say 5 years, there's an option. They could extend it for 1 year, 2 years, 3 years, but at the end of the day, the JC has to pay back the NC. The moment the JC pays back the NC has to redeploy. According to the regulations that we've been discussing here, that redeployment is a requirement. So it's independent of what's happening on the immigration side, the 829s, the 526s, and the conditional green card, whatever. It really has to do with the relationship between the NC and the JC in terms of the money. That I hope that answers your question.
Yeah, I think a good way to look at it, and it's hard for a lot of investors to get their heads around it, but there's a timeline that's a construction timeline. It's completely independent of each investor and their immigration timeline. And the whole idea of having bridge financing and some of the ways that make those transitions between those timelines more smoother is for that reason. So an investor may have a timeline here, another investor may have a timeline here, and the project timelines here. And those are independent of each other. And the bridge financing, those things are really to help those timelines kind of smoothen out.
Okay, thank you very much.
Thank you.